You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we're going to be talking about a very serious topic. You know, anytime you're involved in a car accident or maybe even a personal injury claim, you have to deal with insurance companies and their adjusters. But with us tonight, Mr. Carl Reynolds is here to help us navigate our way through. So how you doing, Carl?
Doing great, Morgan. How are you?
I'm real good, real good.
And you're right. This is an important show. It's because you always are dealing with insurance companies. If you have a claim against somebody for a tort or a wrong done to you, not always. Sometimes you deal directly with a company if it's a corporation. But here to help us answer the questions tonight is my partner, BJ Servant. He does most of the heavy lifting in our office, especially when it comes to keeping up with what is the current law in this state, which oftentimes more than not, is a moving target. In fact, BJ and I were just talking about anti-litem notice in the state of Georgia. It is indeed a moving target, is it not, BJ?
It is. It's changed a lot over the years. What has to be put in the anti-litem notice.
Okay.
Yeah.
Well, what exactly does that term mean?
Well, I mean, when you have a case against a municipality or state or county, you have to put them on notice of your claim. Let's just say it's a slip and fall case that occurred on a city sidewalk, you've got to notify them that you have experienced an injury through some defect in the premises, and put them on notice as to what your injuries are and what your claim for damages will be. And that just keeps moving every year. For instance, if you give them the claim, and we have had to bring cases against lawyers for their failure on this front many times. I know there was a case in Savannah where someone fell because there was a defect in the sidewalk in front of two different places of business. And the lawyer sent the notice to the city of Savannah, but gave the wrong house number. Now, there are only two houses right in front of where this thing happened. But because that lawyer put the wrong house number on his claim, on his notice of claim to the city of Savannah, his case was thrown out by our Court of Appeals, which seems a little silly because it put the city on notice of where the defect was. I mean, any reasonable inspection would have revealed exactly where it was, and the lawyer gave them the sufficient information to find that. But the Court of Appeals threw the case out. That's what I mean. What was the one we were talking about, BJ?
It varies if you're going to sue a city versus a county versus a state. They all have different requirements, but it's a pre-suit notice requirement. If you don't file it, you can't file suit later. And what the courts are doing is kind of eroding, or I guess adding to the statute as to what the notice needs to contain. It used to be a very brief overview of what happened, what the injuries are, and we're going to file a claim. Now you got to be much more specific about the injuries. You got to be very specific about the alleged negligence. You got to be very specific about the amount of medical bills or lost wages. You have to put a dollar value in there that you're willing to settle for. There's a lot of things that have been added over the years and making it much more complex to comply with the statute.
Wow.
And as someone here once said, it keeps on keeping on. There's a recent case in which a claim was made, and the anti-litem notice was complete in every respect, except the lawyer said that the damages suffered by his client was in excess of $100,000. And that case was thrown out. It's a very significant case because the lawyer actually did nothing wrong. I mean, it was a description of what the damages were and would be. And in fact, in that case, I mean, there's no way to know exactly what the damages will be over time. And we'll talk about that later, because one of my pet peeves is this business of where you're in a wreck, you'll get a check and you'll get it quickly. I mean, that's just utter nonsense. But anyway, in the ante-litem notice field, it has gotten to the point that it is actually a minefield for the lawyer.
Oh, wow. Well, that's why. Okay. Well, that's why you two gentlemen are here tonight, to answer these questions in dealing with insurance companies, because many times people don't know where to go or, how to get answers. But we do have a few people that have sent in some email questions that want answers, and I think we can help them out. Our first question comes from Molly, and Molly has a question about her husband. She says, my husband is in the hospital, but our insurance company is denying the claim because we were behind a payment. That's one payment when his injury happened. Now, it was only a week past due, and I was told it's going to be okay. Can they really do that? Now, that's a question that a lot of people have, because sometimes in this day and age, they fall behind on their payments. So can the insurance company deny them because of one simple payment?
I think not. It sounds like an overzealous insurance adjuster who is misinformed about the terms of their policy. Most all policies today do have a grace period within which you can renew the policy, even if it has lapsed for some failure to make a payment. You want to elaborate on that, BJ?
Well, I would just add that if they're going to not cover something, they could either terminate the coverage or cancel the coverage, and there's certain requirements the insurance company has to do before that's valid cancellation. So I think she's okay.
Oh, that's important, because a lot of people don't realize that not only do they have a grace period, but, if you terminate the insurance, that there's a process. You can't just say, oh, I'm not going to cover you, right?
Right.
Oh, okay. Well, just making sure, because I know somebody needed to hear that one. I think we might have time for more and more quick question. And this one comes from Kane. And Kane wants to know, the insurance company is asking me to sign medical and property damage releases related to my claim. Should I do this? Always that question. Should I sign? Should I not sign?
BJ?
Yeah, well, you don't want to give an insurance company unfettered access to your medical information. And if you sign a HIPAA release, is what they're talking about, they can take that document, submit it to any doctor you've ever been to, get all your medical records. You don't want to do that. If they might have access to the information down the line in the case, but at least you'll have a lawyer that monitors what they're getting and able to review what they're getting and know what they're getting. So you won't be blindsided later. So you don't want to sign any sort of release like that. The property damage release that Kane's referring to, I'm not sure exactly what he would be talking about there, but if you don't want to sign any sort of release to release any claim. So you need a lawyer to advise you as to what forms you do need to sign and which ones you do not need to sign.
Okay.
I think the question needs further clarification, though, because they use the term releases. You wouldn't release a property damage claim until you've been paid for the property damage. You wouldn't release them for your claim of medical bills until they've paid you whatever your damages are. Now, I think what the question involves is somebody has been asked to give an authorization for the insurance company to get that information. Right. And sometimes you do and sometimes you don't, but you don't sign a general authorization, because then they can go back and get your medical history for your entire life. Might even include some kind of psychiatric history, which they're not entitled to. So no, you don't do that. You would, as we always say, go to the lawyer, let the lawyer deal with the insurance company, and then he can get them on the right track.
Well, there you go. And we've got two great lawyers here tonight. I have Mr. Carl Reynolds and Mr. BJ Servant. I'm Morgan Dukes, and we'll be right back with more of Law Call next.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes with you this evening. And also, I have two good attorneys with us talking about insurance companies. And insurance companies can really throw you, but that's why we have Mr. Carl Reynolds and BJ Servant here to answer your questions and to even uncover some of their little secrets. So, gentlemen, let's get back to our email questions. And I have one here from Tatum that many people have wondered about, but Tatum asked the question, and it goes a little something like this. The insurance company has offered me a settlement. Should I accept? And how do I know that their offer is a good one? Ooh, how many people have wondered that? Should I accept whatever they're offering? So who wants to tackle this one?
Well, there's so many levels to how to answer that I'm not sure how to even begin. Maybe we ought to have an entire show on that question, because in order to answer the question, you've got to have a lot of information. First of all, insurance adjusters they go to school and they're trained into how to deal with people who are injured, who are, from their vantage point, claimants, and how to get control of that claimant, how to stay in control, how to say the right thing, how to lead them along, bring them along, and hopefully keep them from going to a lawyer. And then they're trained in what the damages are. They've got extensive training that the injured party doesn't have. So the short answer is, if you're an injured party and you're dealing with a claims adjuster, and this is no reflection on the injured party, but they're simply not competent to know what the real value of their claim is, despite Google and everything else we have available today, or to try to find somebody else who has a similar claim and think that their claim is worth the same as the other person. It just doesn't work that way. So if you have a claim against an insurance company and you're dealing with an insurance adjuster, the best thing you can do is go to a lawyer and get that lawyer to deal with the insurance adjuster. That is my answer. BJ, you want to add to that?
Yeah, you have to have a lawyer. The bottom line is, to get an opinion about whether you should accept a settlement, you need to have a lawyer on your side looking at the case and telling you whether the offer is reasonable or not. Anything short of that, you're not serving yourself. A buddy of mine had a client come in. Another thing to watch out for with insurance companies, as Carl said, they're trained to manipulate, might be kind of harsh, but to try to convince you not to go to a lawyer. And so a friend of mine who is an attorney had a client come in who had been in a wreck, and he opened his file, sent all the appropriate notice letters and that sort of thing out. And then he gets his call back from the insurance company. And the insurance company says she already settled her case. And they had sent her $1,000, which she thought went toward her medical bills, as a full and complete settlement of her case. And she didn't know any better. So she signed it, deposited it, case over. So you got to watch out. Not that every insurance company is going to do that, but more and more are doing stuff like that to try to manipulate the injured people to keep them from going to a lawyer, because the lawyer will see what the case is worth and work toward that end. So you need to have a lawyer. This is a very short answer to that question. You need a lawyer.
Absolutely. They need to call you.
There are many, many, many situations similar to that. I know this is going 40 years back, where a client of ours, well, he wasn't at the time, a person was hurt and had a fairly significant claim. This person was from the Mideast and did not speak English. The adjuster came out and looked at the car and talked to the guy and said, "This is only for the property damage. So you sign right here and we'll take care of the property damage." This person signed the release, but the release language showed that it was for the release of all injuries, all personal injuries and property damage. They came to us after that. Now, we're talking about someone who doesn't speak English and had no clue what they were doing. When they then said, well, what about our medical bills and the pain and suffering, et cetera, the insurance company's response was, well, you've signed a release for all of your damages. We took the case and filed suit and took it all the way to the Court of Appeals of Georgia. And here's the lesson in this. The Court of Appeals, in its infinite wisdom in the state of Georgia, said, too bad. Your agreement is contained in the four corners of that piece of paper, and you can't go outside the four corners of that piece of paper because you made a mistake. Now, that's just the law in Georgia. So you've got to be careful before you sign anything with an insurance company. And as BJ says, the easiest thing is to go get a lawyer.
Absolutely.
Even if it's just to look over it and give you advice. The lawyer may not even sign you up as a client, but give you a little advice on how not to proceed.
Okay. And now listen, also, it's important to point out this might be a real good time to let everybody know that they can come to you for an absolutely free consultation. Am I correct?
Us and most any other lawyer will give somebody an initial interview without charging them.
Okay. Now, you also have some information on your website that will kind of help lead and guide them if they have a personal injury claim. Can you speak to that?
Sure. We have a website. It also advises people on what questions they have a right to ask any lawyer they talk to. I think that's the most valuable thing that we offer is a free service to the public. If you're going to hire a lawyer, you may want to talk to 2 or 3 lawyers, and you go to our website and get these questions off, and feel free to ask that lawyer those questions before you determine that you want him or her to represent you in your claim.
All right. Well, and that's important to know. That's why I brought it up. It's so very important to know. Carl Reynolds and BJ Savant are our attorneys tonight. We're talking about the insurance companies. And when we come back, we're going to get into more questions next on Law Call. If you have further questions for Carl Reynolds or BJ Savant, you can find them right here in Macon at Reynolds, Horn, and Savant. Their telephone number is 478-405-0300. And if you like, you can also find them on the web at www.reynoldsinjurylaw.com. And don't forget to follow them on Facebook at Reynolds, Horn, and Savant. That's where you can find them, and they'll be more than happy to answer any questions that you might have. Isn't that right, gentlemen?
Absolutely.
All right. Now back to our email questions. Speaking of questions, we have people that want to know more about insurance claims and their little secrets and how they will put people off and how to deal with adjusters and all of that. Our next question comes from TC. And his question is, I had back surgery 8 years ago and I was doing okay. But a car wreck in June hurt my back again. Now, insurance calls it pre-existing. All right. But I was fine until I had the wreck. Can they deny my claim? I know a lot of people are real concerned about this term pre-existing, what it means and how it can affect a future claim.
Well, if you want, I'll give you the black letter law and then BJ can elaborate on it. Yes, I mean, they can always deny your claim. They can deny anything they want to, and that typically is where the first responsive pleadings go in any case. And the law says they are not responsible for what happened 8 years ago. That is a pre-existing condition, but the at-fault party or the at-fault party's insurance company is responsible for any aggravation to that pre-existing condition. And to the extent that you can separate the two, they would be responsible for the aggravation to the pre-existing injury. Now, sometimes there's a big to-do over, whether that injury occurred or didn't occur, or whether it was over and done with, or was still ongoing. But they are responsible for the aggravation to the pre-existing condition.
Okay.
If Georgia law says that a defendant or somebody causing an injury takes their plaintiff as they find them. So if you run into the back of a Marine's not going to get hurt maybe, but you run in the back of an older lady, she may get hurt. So you take the plaintiff as you find them. And most of us, if you're in your 40s and above, have conditions in our back right now that are naturally occurring that aren't causing us any problems, but they're pre-existing conditions. They make us more susceptible to injury. So a lesser amount of trauma will hurt us when it would not hurt a young, strong person. So what Carl's talking about, the aggravation, you go from pain-free to painful, you're entitled to compensation for that. If you have to go to doctors to get therapy, you ultimately have to have surgery. If it's a result of the symptoms starting after an accident, then whoever caused that accident is responsible, even if a perfect spine wouldn't be causing any problems, or even if a younger, stronger person wouldn't have gotten hurt.
Okay.
Well, in the parlance of trial lawyers, that kind of plaintiff is referred to as an eggshell plaintiff. If it's a very, very elderly, say, person who has all kinds of arthritic changes going on at that time, and they're hit and they're injured further, then you're responsible for that person the same as you would be for anybody else.
Yeah.
Okay.
I tried a case a couple of years ago up in Jones County where my client had been to a chiropractor pretty regularly for a number of years. But she had gotten where her back was good and consistently basically the same. She was largely pain-free. Then she got hit and she struggled for about a year and a half. And then she got back to where she was before the accident. And that's what we fought over at trial, what that was worth. And the jury came back and gave her a nice award.
Okay. All right then. Well, that's good to know. We got some good results there. And let's move on. We have time now for one more question. And this one's going to come from Nick. And his question is about a wreck. He says, after my wreck, I talked to the insurance adjuster who recorded the call. I realized later that I shouldn't have done that. And I asked if I could have a copy of that recording and they refused. Now what? This is always a tricky area after an accident or when you're talking to somebody and they want to record it. Should you allow them to record you or not?
Well, had she gone to a lawyer to start with, the lawyer would never have allowed her to give a statement to the insurance adjuster. That is just simply something you don't do. But having said that, I will say the truth shall set you free. So if you stick completely to the truth and you don't tie yourself up with something you can later be cross-examined with, then it probably won't hurt. But no, you wouldn't let a client do that. You would never let a client do that. And again, it's so often is the case. It depends on the level of the case. If it's just a fender bender, you're a little bit sore, and you talk to the insurance adjuster and you want to work it out just between you and the insurance company, that's fine. But if it's a serious case, no, you should never do that, and you should talk to a lawyer before you do it.
If you do, you have an absolute right to get out of it.
Oh,
okay.
Yeah. She has an absolute right to any statement she's given. They usually hide behind that by saying it's work product of the done pursuant to future litigation. But anytime you give a statement to somebody, you have an absolute right to that statement.
Well, thank you for letting us know that. Carl Reynolds, BJ Servette, I'm Morgan Dukes, and I want to thank everybody for watching Law Call. Good night, everybody.
Good night, Morgan.
Good night, everybody.